Mr. Bamford.
Good morning, Your Honors. My name is Mark Bamford on behalf of George Melendez. In this case, in this appeal, we do not challenge the facts found by the housing court, but rather challenge the conclusion that those facts taken together constitute a material breach of the lease and sufficient grounds for termination of the lease. There is no cause
for an armed robbery about a robbery about a mile away from the premises.
I beg your pardon, Your Honor?
The facts are a robbery, armed
Yes.
robbery about a mile away from the premises.
That's correct, Your Honor. In this case, there's no cause for termination because there was no showing before the housing court that the criminal activity in question threatened the health, safety, or right to peaceful enjoyment of other tenants of other Lowell Housing Authority.
Isn't it a
tenants.
reasonable inference that if the crime occurs in close proximity, that there's a likelihood that it could involve the housing authority premises?
Well, the question, Your Honor, is not strictly proximity. It's a threat which, in our view, relates to the interplay of where the crime occurs as well as what happened. And the what happened doesn't necessarily just revolve around the particular charged criminal activity, but rather who was involved in that activity, such as other Lowell Housing
Is
Authority
this
tenants.
case moot? Isn't he serving time for like 3 more armed robberies?
He's in the current cases. He's has a good time release date of the 23rd of this month, Your Honor.
On this offense, on this,
On other subsequent offenses.
So there's are you saying he's going to be released on the 23rd of this month? From everything?
No, there's a New Hampshire case which hasn't.
But all the Massachusetts armed robberies are going to be.
That's my understanding, Your Honor.
What's may I ask, the case in New Hampshire about?
It's a similar.
Another
it's my
armed
understanding
robbery.
It's a similar case.
I understand your position, which is that under the terms of the lease, and I take it everybody's looking at Section 3C, that's the Appendix A8. Am I in the right place?
I beg your which page you want, Your Honor?
Appendix 8 of the record appendix. I just want to make sure I'm in the right place.
A13?
A8.
A8. Actually, A8 is the responsibilities of the tenant. I would draw your attention to Section 7, which is the grounds for termination, which
Okay, I
are
just
similar
wanted to make
but not identical.
Straighten out on this New Hampshire case, if I might. Has that been tried yet, or is that?
No.
No. So when he finishes here, he's got to go up there and face the proceedings up there.
Correct.
Okay.
so why are you arguing that this case is not moot?
Because it prejudges the issue in this case.
What?
That the issue in these other cases is the same issue that the housing court addressed back in 2005, whether a criminal activity occurring far away constitutes a threat in terms of a threat to the safety and health and well-being of other Lowell Housing Authority tenants.
You mean
It's the same issue.
The same issue because of the New Hampshire crimes?
Yes.
Okay, well, that sort of leads into my next question, which is that if we disagree with your interpretation of the statute and when we determine that this type of criminal activity threatens the health, safety, or right to peaceful enjoyment of the other tenants, simply because your client, it's a little, it might make people nervous to have someone who wields a knife live down the corridor from them. Why is it limited to why would that be limited to the near proximity? Why would it matter if you wielded the knife in Boston or in New Hampshire?
It doesn't, but there has to be a showing that that activity, wielding a knife in Boston, somehow threatens people at the Lowell Housing.
I understand that's your argument, but I say if we reject your argument, that your argument is that because he was a mile away or 3 miles, I forget which it was here, that didn't threaten the peaceful enjoyment of the Lowell Housing Authority. But if we determine that it does threaten somebody's peaceful enjoyment if he's worried that the guy down the hall has engaged or may engage in knife-wielding activity, then why does it matter? Well, that's the basic question. Why does it matter where the knife-wielding activity takes place? If somebody is living there and is worried, why does it matter whether it takes place on the property of the Lowell Housing Authority, or 1 mile away, or 10 miles away, or 100 miles away?
It's useful, Your Honor, perhaps to look at Section 7 of the lease, and there are two types of criminal activity that are mentioned, drug-related activity and everything else. For drug-related activity, the lease says it can occur on or off. For all other activity, there is a restriction that there has to be a showing that there is a threat. If Congress wanted to make all criminal activity the same, they could have said on or off. And I think that's that Mr. Nyman is making that argument that, you know, essentially it's the bad man standard, that because someone commits a crime, there's a criminal tendency or propensity, and that therefore he should lose his right to public housing. But that's not what the lease says. There has to be a showing of threat. And different types of crime threaten in different ways depending on where they are and how they're perpetrated. The single justice of the appeals court, in hearing the motion for a stay, asked questions about were there other Lowell Housing Authority tenants present? Was this a convenience store where Lowell Housing Authority tenants frequented and so forth? It matters the circumstances of the crime in terms of judging what that threat is.
Well,
And
again,
also, I'm sorry, Your Honor.
So, again, I'm looking to the decision of the housing court judge. Essentially, what he did is he said that because that it was a violent criminal act, so that's the first thing. And I take it that takes care of the appeals court decision about gambling or credit card fraud, committed in the same city and a mile from the public housing where the defendant lives is near enough to other public housing residents to threaten their health, safety, and quiet enjoyment.
He's making a conclusion of law, not based on any facts that were heard with regard to that threat.
But it seems to me that it's sort of typical that the police reaction to certain violent crimes, mainly robbery, armed robbery, and murder, is fairly aggressive. There could either be a hot pursuit right to the door of the person's home, or once they find out where the person is, they usually surround the place. Doesn't that interfere with the other tenant's quiet enjoyment?
The statute does not say robbery or murder. It talks about the particular case. And in this case, there was nothing that talked about threat to safety. There was no showing of police coming to the housing authority and so forth.
But this was an armed robbery, wasn't it?
It was an armed robbery,
The convenience
an armed
store.
assault and attempted robbery
The knife.
with a knife.
Yeah, have you read the Pennsylvania case, Powell versus Housing Authority, that Justice Kerman cited?
Yes,
Judge Kerman cited?
Yes.
And can you distinguish that from
Well,
this case?
it's a Section 8 case. It's an entirely different standard. The standard is merely, I say merely, but it's violent criminal activity. In this case, this would constitute criminal activity, but that's not the standard that's applicable here.
But under Section 8, violent criminal activity, does it say anything about whether it must take place on or off the premises?
I don't have that in front of me, Your Honor.
At least Judge Kerman's decision says housing authority, he characterized it as the Pennsylvania decision as saying that housing authority was not required to prove that activity threatened health, safety, or right to peaceful enjoyment dwelling premises by other residents or by other persons residing in the immediate vicinity of the tenant's apartment.
And the reason that court did not reach the question of threat to other tenants is because the court based its ruling on finding a violent criminal activity. So it was a different test that was, so the court never addressed the standard in this case. And I would just like to address something Justice Cowan mentioned earlier about the feelings of other tenants. The test must be an objective standard in terms of how other tenants are being threatened. It cannot be based on how other tenants feel, their subjective concerns. You can imagine how that would cause mischief amongst tenants in the housing authorities.
But an objective standard, wouldn't it be objectively reasonable that somebody is in fear of someone who lives near him or her who has been charged or convicted of an armed robbery?
Well, Attorney Nyman, in his brief, there's an affidavit that talks about the subjective feelings of other tenants. And I go back to, at the trial, there was, it's my understanding, no testimony taken, and there's nothing in the decision by Justice Kerman that talks about...
Isn't the appeals court reasoning in the Bryant case a better one for everybody to apply, namely, not the subjective fear that, you know, if I know that I'm living next door to a serial rapist, I may or may not be, you know, fearful because I say I take precautions. But essentially what the appeals court did was to say that what you do is you look at crimes that are physically destructive, violent, associated with violence, or visibly asocial, and that doesn't address whether it has to be on or off the property, which seems to me also at issue in this case. So one is, this is a violent crime, but it's off the property, so can it be 1 mile off, 2 miles off, 3 miles off, 4 miles off, 5 miles off?
But why does it matter where it occurs? I don't see that 1 mile, 5 miles, 10 miles, 20 miles, 100 miles makes a difference.
The key words are threatened.
Correct, Your Honor.
That's the key words. And so you've got to use a little, under the objective standard, a little common sense. Because, I mean, suppose this guy's short of a little cash to go out and buy beer some night, and he said, well, hell, I'll just go next door and take my knife and rip the tenant off over there.
Well,
I mean,
and
he's shown such a propensity to do such vicious acts that he does threaten the well-being of this community where he did live.
And that, Your Honor, is the position that the federal public housing law takes with regard to drug activity.
No, I understand, but but drug activity can be very non-threatening. The case that we had was, you know, the visitor who had some personal use cocaine in their pocket, right? Not threatening to anybody else. For different societal reasons, the federal government and state and local governments have said, we don't want any drugs. We just don't want any drugs. We can't tell you specifically whether somebody will lose it or not. We're not saying that every single drug user is violent. We're not saying that every single drug user is going to push it. We're just saying we want no drugs. So that's one policy. Then there's another policy that says that if you are violent, you know, or you display violent conduct, rape, murder, armed robbery, whatever it is, wherever you are, that's a threat to your next-door neighbors.
But the lease does not say violent activity. It has to be activity that threatens. There could be violent activity that occurs, you know, across the country, and it would be hard to understand how that would possibly put anyone at a low housing authority development in any danger whatsoever.
So if Al Capone maintains an apartment at the Lowell Housing Authority and commits all his crimes in Chicago, the fact that tenants living next door to him might be scared to death is completely irrelevant.
That's not the case at hand, Your Honor.
Well, it's pretty close.
Pretty close. He's robbing banks, too, isn't he?
I suppose one response is to say engages in any, you know, criminal activity, period.
That's right. And they did not say that. And back, if I could just address the Bryant case. In the Bryant case, they talk about criminal activity that's sufficiently unrelated to the operation of the housing authority. And this, and the crime being visible to the housing authority. Because of where the crime occurred and the type of crime, it was unrelated and it was invisible to the current tenants of the housing authority. So I think Brian actually supports the tenant's case here. And also in Bryant, the court rejected the chain of conjecture going from the crime in question to all the bad things that could lead to someone if they had their credit card stolen. I think there was a discussion about you have your credit card stolen, there's an emergency, you can't use it, and therefore you're in danger. The appeals court rejected the trial court's reasoning in that regard.
Thank you, Mr. Bamford.
Thank you.
Mr. Nyman?
Please the court, I'm Philip Nyman. We're here with Kathleen O'Hagan. We represent the Lowell Housing Authority. Respectfully, here's a man who admits committing an armed robbery, doesn't dispute the facts, does it in a minority neighborhood a mile from the housing authority with a knife, gets charged with not only armed robbery, but assault and battery with a dangerous weapon, armed robbery, comes back to the housing authority. You got to know we're living in the city of Lowell. He gets arrested, he gets charged, gets reported in the Lowell Sun. Everyone in Lowell reads the Lowell Sun. You got to respectfully, the housing authority in Lowell takes care of the most vulnerable people in the city. We've got disabled people. We have over 57% of the tenants in the housing authority are elderly or they're disabled.
Mr. Nyman, let me ask you this.
Yes, Your Honor.
Your client drafted this lease, correct?
My client?
Drafted this lease.
Yes.
I'm looking at paragraph 7B8, and it says, abuse of alcohol by any member of the resident's household, which the Lowell Housing Authority determines interferes with the health, safety, or right to peaceable enjoyment. Okay, so there's a recognition that some abuse of alcohol doesn't interfere.
Yes.
You could have put that into paragraph 6. You didn't. You just said in any criminal activity that threatens. And the question is, who makes that determination? Because you didn't say any criminal activity, comma, that the housing authority determines interferes with. It's as if there is some criminal activity out there. It also doesn't say any criminal activity. We don't want anybody engaged in criminal activity. Frankly, the Bryant case to me was, if I may say so, hardly persuasive, because somebody who's ripping off credit cards stealthily may be just as dangerous to a next-door neighbor. So I have a very ambiguous lease provision. My question to you is, by what measure do I discern, other than in Justice Kerman's language, you've got to be crazy if you don't think this is threatens, how do I determine that? Who has the burden of proof? What should they be showing?
Respectfully, Justice Marshall, I believe that the housing authority, as the landlord, as the head of taking care of almost 2,000 people who have an obligation to take care of and provide safe housing for all of these people in the city of Lowell, are very well equipped to be able to make this decision.
Well, then why didn't they draft it exactly as paragraph 8 was drafted, which says, engaged in any criminal activity that the housing authority determines interferes with the health, safety, and welfare? Straightforward provision. I've got two provisions that are drafted differently, and when I interpret contracts, I have to see whether it means something different.
Respectfully, Your Honor, if the court would look on A8 of our appendix, you'd see that the resident's responsibility, and the resident's responsibility is to refrain from criminal activity that threatens the health, safety, or right to quiet enjoyment for any Lowell Housing Authority development by other tenants.
Now, that's where I started, but you terminated them at any time, and then you explain the terms on which you terminate them, and the termination provision is not coextensive with. It almost repeats it.
Well, except on A7, respectfully, Your Honor, and it says Lowell Housing responsibilities to permit the residents to peacefully and quietly enjoy the premises, respecting residents' rights to privacy. And then it says to terminate the lease in accordance with its provisions and the provisions of the grievance procedure. All proper steps exhausted before we do it. But respectfully, Your Honor, this is an armed robbery. This is an armed robber. This is a man. The questions that are being asked and that are referred to were the same questions that were asked by Judge Parada. And quite frankly, after hearing that we weren't on the premises and it wasn't a tenant and no tenant fortunately was in the variety store where they could have been killed or where they could have been stabbed, she then said, I'm going to grant a stay. And then a month later, when the man was charged with committing an armed robbery, leaving a note and threatening a bomb, saying, I have a bomb, I'm going to rob the bank in New Hampshire, robbing an armed robbery in Lawrence, Massachusetts, another armed robbery 12 miles away, massive headlines in the newspaper. We then submitted that to the judge and said, could we please have a reconsideration? And immediately, the stay was vacated. Respectfully, Judge Marshall, I don't think people should be required to live in a position where they could be killed
Nyman,
themselves.
I'm not asking anybody to be required to live anywhere. I'm asking the Lowell Housing Authority to draft the next one might be something different. This case may be clear to you. It may have been clear to the housing court judge. The next case is not so clear. It's not so clear. I don't know if the housing court, if the Lowell Housing Authority can outlaw any tenant who engages in any criminal activity. I don't have that question, but that's not what this lease says. Right?
It doesn't say that, and could we go back and could we review and try to make it and try to add that provision? The answer would have to be yes, we could, as long as we're not violating any federal provision. And I don't believe that we are. But until, excuse me, Justice.
I'm just wondering, aren't you saying that it's really implicit when you take all of the materials together that the housing authority is approaching it that way when you look at the statement of the tenant's rights, the authority's responsibilities, and all of that?
That's what I tried to articulate, Justice Ireland, and in my opinion, it is in there. The tenant has a responsibility not to engage in violent crime, and the housing authority has an obligation, if the tenant doesn't meet its responsibilities, that it has to fulfill its responsibilities to the other 2,000 tenants that are living there.
Is it possible to read the Section 3C, that's the one that has the threatening the health, safety, or right to quiet enjoyment, that's a tenant has to refrain from that type of criminal activity or any drug-related criminal activity on or near any LHA housing development, that the reason that the drug activity is required to be on or near the housing development because it really doesn't affect your tenants if there's a drug sale in Lawrence. I mean, that doesn't really affect it. Drug selling is not good, and it's antisocial, and it has all sorts of other problems. But if the drugs are sold in Lawrence or Boston, it isn't the same as if the person is selling them on the property, whereas a violent crime is different. No matter where it's committed, it's showing the violent tendencies of the person.
And I think that's probably the answer to what it is. As someone pointed out, I think perhaps you, a sale, or a single sale by somebody in the dark of night inside an apartment of some marijuana may not, as far as the federal government is concerned, is so bad because it relates to drugs that they should be should be evicted. And I think what Justice Cowan just said may be the answer to this, that it's the crime is so bad, no matter where it's no matter where it's conducted, we should have the obligation, after reviewing the facts, after looking at the police reports, to make a decision that this person could affect the lives and safety of all of the people who are living in the housing authority. And if you carry what council wants to do, that would mean every time we went to evict someone, we would have to bring in a half a dozen tenants, some elderly, some people who couldn't get there, some possibly disabled, and have them come in and say, oh, I'm afraid that my life is in danger? As a practical matter, that isn't practical. It just doesn't work that way. I think what Justice Ireland said at the beginning is, isn't there an inference that an armed robbery is very dangerous to the health, safety, and welfare of the people who are living in these apartment buildings? These aren't one-acre, single-family residences like one would find in the suburbs. These are apartment buildings. They're tenants. Some of them are 3 and 4 stories. They're all very close, and they're all in lower-income sections of the city of Lowell. And respectfully, it is the position here that it is so clear, though I agree with Justice Marshall that if in the future to take away some apparent clarity or to make it more clear, we could revise the lease, but respectfully, Justice Marshall, I feel that there isn't an ambiguity. I think that if this were not a crime like this, I don't think the police would be around making arrests. And then when you compound it with whatever else this person did, it reaffirms the judgment that the housing authority made to terminate this person.
Well, it's interesting context, but the subsequent offenses are not the basis on which his tenancy was terminated.
I agree, but I respectfully, Justice Cordy, and I agree with that, and the only reason it was put in because they argued in their brief that the judge had stayed, and we argued that because of the fact that he wasn't there anymore, it shouldn't, the issue was moot.
But your argument certainly wouldn't be different if there had been no subsequent arrests or convictions.
I don't think one violent crime is any better or worse than 4 violent crimes.
Wait, are you arguing still, is your position that the case is moot?
In our opinion, the case is moot because he's no longer there.
And he's not coming back.
And from what counsel has indicated, he's not going to be back. They are not known for their kindness and generosity to Massachusetts criminals in our bordering state of New Hampshire. So
But in any event, even if he came back, the case could be brought at that point, correct?
Or if he did come back and he wanted to apply for public housing, he then could apply. We then, I believe, would then put him on a list, but I'm not going to misrepresent to the Supreme Court and say that we'd be pushing to get him in, because we wouldn't.
Is this the type of case that is capable of evading review because it will affect other people who were charged with criminal acts?
No position with any criminal activity, and it might be.
We don't act with respect to any criminal act.
No, I mean of this nature. Okay.
But it is the policy of the Housing Authority that when there are violent, severe crimes like this, we take all possible steps to protect the welfare of all of the other tenants who are living there.
Thank you, Mr.
I have
Nyman.
nothing else to add. Thank you very much.